Good morning and welcome to the BBA's 60-minute webinar on Iran sanctions, impact and implications for banks in partnership with SQA Consulting. My name is Philip Allen, I'm the Director of Learning at the BBA, and today to discuss these matters I'm joined by presenters Justine Walker, BBA Director of Financial Crime, Jeremy Round, Managing Director of SQA Consulting, Zia Allah, Partner at Eversheds, Dr. Saras Mehdi Zahi, Director, British Iranian Chamber of Commerce. Before Justine kicks us off, may I remind you that this is an interactive webinar in which you can participate by asking questions throughout the presentation. Just click on the Questions tab just underneath your screen and type out your questions. We will endeavour to answer as many questions as possible. Justine, over to you.
Great, thank you very much, Philip. Okay, good morning, everyone. I mean, obviously, last month we have seen a significant change in the sanctions landscape, and this is creating considerable opportunities, but also considerable compliance challenges for some of our members. For the BBA's part, we've been fairly actively engaged in the dialogue with a range of stakeholders, both within the US, within Iran, within the UK, and within Europe on looking at these issues. We have been engaging with the UK Treasury and the UK Foreign and Commonwealth Office on areas where banks are seeking greater certainty. We've been responding to business requests on their interest, on understanding the appetite of banks to re-engage with Iran, and indeed we've been engaging with the broader international community on just the new landscape. So this session, my colleagues here are really going to advance the thinking around where the opportunities may be, where the challenges may be, and really what people need to think about to ensure that they remain compliant with, certainly with the US framework, which is still a considerable framework in place. So, Zia, can I pass over to you to help set out where we currently are within the current legal landscape?
Thank you, Justine, and thank you, Philip, for inviting me here to speak today on this, what is one of the most important issues to arisen in international sanctions over the past few decades. What I'm going to do is just essentially, before going into the impact today and in the future, just over what happened previously for the audience, just so we get a historical context to how and where the JCPOA came from. Flick through. So we're going to look at how we got to the JCPOA. Look at the issues from a practical perspective, considering we're now in a diverging world, as I put it. So moving from absolute convergence internationally from an Iranian sanctions perspective to a challenging divergent approach across the various stakeholders in relation to Iran. We'll talk about some of the compliance challenges and practical tips, and I think this is where we're going to see most of the interaction, I would imagine, with our audience, and I think Cyrus will have a lot of input here in this section as well. We'll briefly touch upon the future of sanctions, particularly in light of the Hezbollah Finance and Prevention Act of 2015, a piece of legislation that's sort of gone under the radar to a great degree, but which many commentators think actually may have a part to play going forward. And then Jeremy will deal with some of the practical screening challenges in particular that the recent changes have brought and will continue to bring going forward. So, as I say, the JCPOA essentially is the biggest change we've seen in relation to international sanctions for some time. In my previous role as Global Head of Sanctions at Barclays, going back 7-8 years, we didn't have much to worry about, despite what many of my team thought, from a sanctions perspective. Back then, it was more or less a case of screening lists, and then over the subsequent years, 7 or 8 years post, we saw the development of international sanctions generally, but Iran was the real template for sanctions regimes as they're implemented today. You need look no further than Syria and Russia-Ukraine as prime examples of how that's manifested itself post the Iranian sanctions regimes. But the development of international sanctions against Iran have great historical context. And so, as I say, it's probably worth just touching upon that before we go into the JCPOA itself. The actual start of this is more like a 40-year journey for everyone involved from a sanctions perspective, starting back with the Iranian Revolution, the US embassy crisis, and we see a movement towards the implementation of sanctions on a very gradual scale to commence with. It's not until, in practical terms, 2008, 2009, 2010, that in reality the real pressure was brought to bear upon the Iranian regime from a sanctions perspective. In 2008 we saw the U-turn exemption end, which was the US dollar clearing exemption, essentially permitting non-US companies to clear US dollars through US depository institutions. And then post-2010 we started to see the implementation of so-called secondary sanctions against non-US persons, or potential implementation of secondary sanctions against non-US persons. And that really was a game changer for everyone, because for the first time foreign firms and foreign central banks in particular were at risk of potential sanctions from the US government. And obviously many jurisdictions who had been up until that point quite content to deal with Iranian parties were suddenly very concerned in relation to what their risks were going forward. So we had bits of legislation from a US perspective, like the Comprehensive Iranian Sanctions Accountability and Divestment Act, ISARDA. We had various National Defense Authorization Acts implementing foreign potential sanctions against foreign financial institutions and other institutions as well. In and around 2011, 2012, the EU also made some significant changes in relation to its sanctions regime, and I talked at the beginning about this divergence to convergence process, and in reality 2012 was probably the year in which we had absolute convergence between all the international stakeholders in relation to sanctions against Iran, and just a year later we see the start of the negotiations that lead to the finalised Joint Comprehensive Plan of Action. And so let's just focus on the JCPOA in a bit more detail now. The JCPOA itself was agreed in principle in 2013 and started life in around January 2014. And it took another year or so, year and a half, until Iran and the P5+1, so the permanent members of the United Nations Security Council plus Germany, agreed on this Joint Comprehensive Plan of Action. In essence, that JCPOA provides for, because it is a living and breathing plan that will run for many, many years to come, provides Iran with phased sanctions relief once various steps are verified and commitments have been verified throughout the process. It's important to say that post-implementation day, one of the key issues that remains, and one of the key challenges that remains, and we'll talk about this in great detail shortly, is the fact that US primary sanctions, however, remain in place. It's, I think, still a little confusing for some people out there, despite all the publicity that we've seen in relation to the JCPOA, that US persons generally are still not permitted to trade with Iran. And so that's the sort of basic template one needs to consider from a US person's perspective. What has happened is that US secondary sanctions have been lifted and potentially could be snapped back in place, and we'll talk about snapback shortly, if Iran fails to fulfill its commitments. So US primary sanctions remain in place for US persons. Two key dates for us to consider. The JCPOA itself was formally adopted on the 18th of October 2015, and at that point it wasn't actually clear how long it would be until implementation day itself took place, i.e. the day upon which EU sanctions would be lifted in a wholesale manner and US secondary sanctions would be lifted. And many commentators, myself included, thought actually it was going to be a lot later than it was. Political impetus as it is, we actually thought implementation day catch a lot of people out, and it came into force a lot earlier than people thought, on the 16th of January, a Saturday, to make it even more practical than normal. On that day, we saw revised guidance issued by the US Treasury's Office of Foreign Assets Control. The EU also published a very detailed information note, and both of those documents are hefty, comprehensive, and in part confusing. There's no point beating around the bush on that point. There are some areas where it's relatively clear what a person can and can't do. There are other areas, as Justine and Cyrus will hopefully talk to later on, where there still remains some issues of clarity and context. The important thing to consider, as I say, that both those EU and US notes talk about potential snapback of sanctions. So again, something to consider from a practical perspective when looking at the position going forward. I'm just going to look at the changes that have occurred from a UN, EU and US perspective very briefly. The UN's current Security Council resolution 2231 of 15 essentially terminated all previous resolutions and maintained specific restrictions in place again in relation to missile technology, nuclear technology, etc. The EU has essentially listed all sanctions against Iran subject to similar restrictions under the EU, i.e. related to military goods, nuclear and missile technology. So there still remains an EU sanctions program against Iran, but focused on those particular areas, and there still remain individuals and entities subject to asset freeze on the EU consolidated list of targets. But the key changes for those who were previously impacted by Iranian sanctions are that the sectors that were targeted, namely finance, banking, insurance, petrochemicals, oil and gas, energy, shipbuilding, gold, precious metals, etc., the sanctions have been removed in relation to those particular sectors. So to all intents and purposes, in theory, it's potentially business as usual in relation to trade with Iran, subject obviously to the commercial and other risks that we'll talk about shortly. From a US perspective, as I say, the primary sanctions will remain in place. Sorry, slides are good. And in fact, the changes have actually been applied to non-US persons and the impact of secondary US sanctions. So again, they essentially were targeting the same areas that the EU sanctions targeted, namely finance, banking, energy, petrochemicals, shipping, etc. So non-US persons are no longer at risk of potential secondary sanctions for engaging in activities with Iranian persons. As I say, those sanctions were comprehensive, they were complicated, and often very difficult to navigate for non-US persons, hence the position where people adopted actually no business is better than trying to figure out what business I can do with Iranian parties. It's very important also to note that at the same time as the US changes came into play, the US issued what's called General License H with respect to the Iranian sanctions regime, and that license essentially relieves US parent companies from certain sanctions adopted to discourage their foreign subsidiaries from engaging in Iranian-linked business. So US-owned or controlled foreign entities are able to engage in certain transactions relating to Iran that would otherwise be prohibited. So that, again, that's one of the most significant changes to impact US-linked foreign controlled entities. Again, it's important to understand that they still may not export or re-export US origin goods to Iran without separate authorization. So again, it's an important thing to remember. And in fact, the wording of General License H is actually fairly limited. It's not. It doesn't go into great detail. It does provide some information as to how a US person can assist the foreign sub in terms of changing operating policies, in terms of the utilization of automated software from a group perspective. But that clearly carved out any financial transactions, so no financial transactions like sanction screenings, engines, etc., and the like that may enable US dollar transactions to go through. You can't utilize those types of operational processes from a group perspective, but other automated processes. So things like the location and allocation of stock, as an example, could potentially fall under that particular exemption. I think that the important point to make here, though, is that most US persons are adopting a relatively conservative approach to this because the guidance is very limited at the moment about just how far that exemption applies. So it's going to be, I think for a while, we're going to see people treading very carefully with respect to General License H. I spoke about the fact that we'd reached, by about 2012, this point of convergence. And in a way, for those of us that are having to navigate our way through international sanctions, the position became relatively clear, as I say, binary to some degree. You either were able to do something with Iran via certain exemptions that were in play in the US regime as examples, or you were not. It was fairly clear. We're now moving back to a divergent approach, particularly, as I say, as the US maintains its primary sanctions and the rest of the world, the EU taking the lead, removing or relaxing the majority, if not all, of the sanctions in relation to Iran. So it starts to become a bit more of a challenge for those parties seeking to navigate their way through the commercial realities of dealing with Iranian parties. And so there remains some very considerable practical challenges, whether you're going in or staying out. And I think that's the really important point to make here, is that there will be challenges for all, particularly banks, in relation to the Iranian conundrum going forward, even if a bank decides that it won't or it can't facilitate any trade with Iran, because of the fact that other people will be going back into Iran. On that, there is no doubt. It's the intention of all the parties under the JCPOA that trade does happen. There's a real political will and desire that it happens, and certainly Justine, Cyrus and myself have been talking to many of the stakeholders from a geopolitical perspective, all of whom are trying to persuade everyone else that it's a good thing and everyone should be facilitating that trade. I think the nuances in and around the particularly the legal complexities around a party's ability to trade is something that is still being ironed out and will take many, many months, if not years, to iron out ultimately. Some of the issues that we are focusing on and the greatest challenges arise in relation to are listed for you on this particular slide. I think the potentially greatest issue for banks is correspondence, the question of correspondent banks, whether you in fact clear on behalf of another, or whether you rely on another to provide you, your institution, with correspondent facilities. And that's whether you intend or are able to deal with Iran, or whether you intend not to deal with Iran. Because interposed within those correspondent relationships will be institutions that are dealing in some way, shape or form with Iranian parties. Some of the corresponding challenges that arise as a result of the decision to go in or stay out include contractual provisions I talk about it in terms of protection and deflection. So if you are intending to deal with Iranian parties, this threat of snapback needs to be looked at from a protection perspective. If you are not intending to deal with Iranian parties, but you know that people you deal with may well be, then this issue of deflection, deflective protections within provisions, and we are seeing already new correspondent letters and contractual provisions being issued by the major clearers to their correspondents about what they will and will not do from a clearing perspective, and the types of warranties they want to see and reps they want to see from their contractual parties. Trade finance, perennial problem for all sanctions compliance personnel, will continue to be an issue going forward, particularly as we start to see a ratcheting up in commercial activity with Iran. And I think underscoring the compliance challenges to that, we have the Revolutionary Guards Corps issue. It's dare I call it the elephant in the room, but it certainly has a huge part to play because the sanctions remain in place in relation to dealings with the IGC. It's well known the IGC has multiple ownership and stakeholder arrangements with many of the national and subnational corporate entities within Iran, and actually trying to navigate your way through that will be one of the critical issues for parties to understand. So due diligence is going to be absolutely key. Let's not forget, and Iran still has to deal with this particular not elephant, but issue anyway, is the fact that it still remains one of two countries that Fatah asked member countries to avoid for all intents and purposes from money laundering and terrorism perspective. It, together with North Korea, remains a Fatah blacklisted jurisdiction. So the Iranians are going to have to make some very, very speedy progress in relation to the implementation of legislation to deal with anti-money laundering and terrorism, to allay those fears and concerns. And certainly, even if you get over the issue of sanctions from a banking perspective, you still have to deal with both US and HM Treasury guidance in relation to dealings with Iranian firms on that basis, from a regulated firm perspective in particular. It's not something that you can ignore. You have to deal with it. And then again, US persons will have this perennial issue of trying to understand, again, any linkages between themselves and Iranian-linked activity, whether it's in relation to correspondent accounts, whether it's in relation to trade finance, whether it's in relation to any aspect of sanctions compliance. And as we discussed earlier, the issue of their foreign-owned, controlled subsidiaries is going to be a tricky one, and it's one again that I know a number of companies have been looking at for a while now, and are trying to navigate their way through. And we were having a discussion before we started the webinar just in relation to the guidance that's been issued by the US and EU authorities, and certainly my view is that we're going to have to see some very much more detailed guidance on behalf of US-owned foreign subs in particular, before many of them will become comfortable that they can in fact navigate commercial activity with Iran with a great degree of confidence, certainly the confidence that a regulated institution may well require before doing so. I've set out for you on the next slide one of the sort of training slides that we use in our BBA sanctions workshop, and that applies equally to all sanctions regimes, not just the Iranian sanctions regime. But actually, when looking at it from an Iranian perspective, I think it actually is quite a good summary of the issues you're going to have to consider with respect to going back into Iran, and who you're going to have to deal with and get buy-in from in particular if you're seeking to go back in. And it's split between internal and external stakeholders and your internal and external communications. Internally, obviously, some very key decisions have to be made by institutions from a policy perspective. what's the risk appetite of the business in relation to Iranian-linked activities, and flowing down from that risk appetite and policy statement will be a whole series of internal decisions to make, which are increasingly complex the bigger the organisation becomes, and so the challenges also become greater. And I think that's, again, some of the issues, an example of some of the issues that perhaps the politicians have not addressed adequately prior to implementation day, because externally, to a businessman who just, as Cyrus says, just wants to sell widgets, either to or from Iran, it shouldn't be that complicated. I want to open an account, I want to sell, I want to get payments. It's hopefully straightforward. Actually, what many people don't understand are the internal machinations of the financial industry and banks in particular, and what complex beasts they are. And there are lots of different issues to deal with. Jeremy will touch upon one of them in terms of just the screening elements of what you have to deal with from a compliance perspective. There comes a plethora of other issues, like the contractual documentation we discussed earlier on, like whether in fact your business has US persons in significant decision-making roles, etc., that may prevent them from being involved in this type of discussion. A number of different issues. Similarly, your external stakeholders have to be brought into the process as well. Certainly, the shareholders of some of the major European banks, I'm sure, were not particularly happy with the multi-billion-dollar fines that were implemented in relation to previous sanctions on compliance, and that remains a risk going forward for many, many parties. So, as I say, there are a number of different stakeholders that one has to consider in relation to this, and they're set out for you there. In terms of the future, there are a number of, I think, areas for us to consider. I mentioned at the beginning this piece of legislation, the Hezbollah Financing Prevention Act of 2015, that sort of came under the radar. It actually only comes into force in April of this year, and the provisions relating to it will then hit 120 days post. So actually there's a fair bit of time in relation to it actually impacting day to day. But why is that of relevance here? Particularly if we think of Hezbollah as a Lebanese-based or located organisation, and actually limited sanctions focusing on Lebanese TV stations, in particular in this act. Well, why? Well, because of the allegations that Hezbollah is an Iranian proxy, and the potential for foreign financial firms to be impacted by this legislation. So again, we're going back to pre-implementation day type legislation, focusing secondary sanctions on foreign firms. We have the issue of snapback that still is to be clarified. Certain EU and US promises about whether in fact contracts entered into between implementation day and any potential snapback will be grandfathered or not. The US-Iranian elections are very key issues to consider as well. Iranian presidential elections coming up in the next...
Iranian parliamentary elections.
Parliamentary elections, thank you,
26th of February.
So they're coming up shortly. The US elections, one will have seen as well, will impact the geopolitical situation and also the commercial risk going forward.
Thanks, Ian. We're going to pick up on all of those elements when we move on to the discussion. Jeremy, I'm going to hand over to you, but before I do that, can I just remind people that we are taking questions. You can hide your questions if you don't want them to be viewed publicly. You just pick the hide option. So, but Jeremy, can I ask you to give us a couple of minutes on just the, from your perspective, how we're going to approach from a compliance screening side?
Oh, thank you, Zia. Yes, from my perspective, it's all about lists. And on the Monday after implementation day, HMT sent me a wonderful email about lunchtime saying they'd reduced their list by 332 entries, which was great. And that, when we looked at it in detail, that actually came out to be 478 names when we included all the aliases. And there we can see on the diagram here the HMT list broken down by program. and we can see there's 2 Iranian-related programs in HMT, and effectively the same in the EU list. HMT mirrors the EU list, but it's much more practical to use. And we see the human rights program did not change at all, but nuclear proliferation reduced significantly. But from a HMT asset freeze list, which is what banks use to screen, is the driver of this process, what we have now really is just Iran being another country like Tunisia or Burundi. There's rather a large number of targeted individuals and companies, but it's just a normal thing. There's no great shakes when it comes to the screening process from a HMT EU perspective. However, if we move on to the OFAC list, things are rather more complicated, and as Zia went through the regulations and talked more and more about America and things that are happening there, how much more complicated the issue is, more blurred. The SDN list was much more complex, still is much more complex in respect to Iran than the HMT EU list ever was. And there I've listed all the programs which are Iranian related, quite a large number of them. And in blue is the number of targeted sanctions against those programs, and in red is how many are left after implementation date. So you can see that rather a lot of names disappeared from the SDN list, 871. Also on that list of programs is non-proliferation of weapons of mass destruction, which of course isn't Iran specific, but turned out to be heavily impacted by the changing of the Iran sanctions. Now, if we rewind a year, OFAC had a big SDN list, which was lovely, and it also had lots of other little lists, called things like the SSE list and the Part 561 list, the SSI list, which is mostly around Russia, Ukraine, the PLC list, which came out in 2006, hasn't changed since, and these are all held separately, sort of stovepiped, some in different formats, actually, in the main SDN list. All these tend to not be asset freeze lists. And sometime in mid-2015, OFAC decided to stop publishing these lists separately and created a new consolidated list, it's called, of targeted sanctions, which just have account restrictions rather than asset freezes. And what we found is the Iran program, and it's halfway down the little graph there, which was quite big, over 400 targeted names, was pretty much moved into the consolidated list to form a new list. Which was took me a little by surprise, I must say. There are still about 13 names left on the Iran program. Why they haven't all moved, I can't tell you, but there's still a little dribble left there. But the main bulk of them, which are names and bit codes and vessels and vessel IMOs and aircraft tail codes, moved to this new list. Now, this will cause some banks some issues. I have the keywords WorldCheck, if any WorldCheck users out there. Other list providers also provide similar features, but you will now need to include new keywords, NS-Iran, if you want to include that list, much like the FSE list or the SSI list or use for screening, in your screening. You can also include the new umbrella keyword, OFAC non-SDN, which includes all those lists. If you use the umbrella keyword, it will keep you up to date from this point forward. Which could be very useful to you. If we can move on, a great implication for banks from this change was the big reduction in names of the non-proliferation of weapons of mass destruction.
Move on.
Oh, we've moved on, thank you. And one great fallout of this, which was a little unexpected, was the number of vessels that were removed from lists. And banks have long had issues with vessels and their names, particularly in payment screening. So a lot of vessels have been called personal names like Maria and Teresa, and banks have been pulling their hair out at times on how to screen these and should they screen these, and putting in ever more elaborate mechanisms for removing false positives created by these. Well, they've gone. They're not on the list. We no longer have a vessel called Abba. Aha. We no longer have a vessel called Alias or Maria. And particularly interested South African banks, we no longer have the ZAR, which of course is coincidental with the South African currency code for the rand. So they're gone, so that's great news. Obviously similar reductions in vessel IMO. In fact, there's barely any vessels left now on the OFAC list. So what was a very major issue for banks has been relieved. And that is all I've got to say on the real implication of banks on screening, the list implications.
Okay, thank you. And we'll maybe come back and discuss some of the aspects we were speaking about before the session went live around, former government of Iran entities which are now no longer feature on any lists, and how we potentially risk manage that. But I would like to sort of now move on to actually really discuss what this really means by way of business, by way of Iranian or European British business, and by way of actually what's happening in Iran. So, Cyrus, could you give us an overview of, from your perspective, what you see as the priority areas around how banks can potentially think about due diligence in Iran? So I'll hand over to you. Thank you.
Thank you very much, Justine. Thank you, BBA. I must actually thank BBA especially because I know they've been working very hard on trying to maneuver through the sanctions and represent really both in Iran and over here the challenges that are ahead. And again, thank you to Zia and Jeremy for a really comprehensive presentation. You've done me a great favor. I don't need to say anything, really. You've covered all the major issues. I think Justin mentioned that I must say that actually I just deal with business. I'm not a banker, nor do I have financial crime or in sanctions training. So I will only talk from the business side here. And what is really the Iranian view of the JCPOA, what they expected, what they wanted, and what they think happened post-implementation, pre- and post-implementation. Of course, we can't deny that the JCPOA was a great testament to diplomacy. And really, it just proves that where there is will, there is way. And Iranians are really over the moon. But when the JCPOA was agreed and done, and they really pushed ahead, basically were committed to the letter of the JCPOA. In the point that you mentioned about the implementation being caught out, how early it was. When I was in Iran in November, I was being told by everybody there that, well, not everybody, but people who were involved with certain things, that 15th of January is the day where they are aiming for the implementation. When we came over here and talked to various stakeholders on this side of we were being told, end of first quarter is the possibility. And the fact that actually they happened one day after the Iranians wanted to happen is really, again, a great testament to Iranian commitment on what they wanted the JCPOA for the implementation to happen. What they feel a little bit let down is actually on the goodwill side of the JCPOA. I think this is very important to mention here. They feel that a lot of the actions which are now being taken by the banks, which is to do with the effectively reactivation of the banks, to do with the training, to do with compliance, should have happened post-JCPOA. Not now. There's a 6 month delay in that. It is, I must say, it is great that we now have had on the 18th of January, we had the Tertiary Bank, International Bank and Bank Melli in London. The HMT actually gave them the license for reactivation. Bank Sepah has now been, Bank Sepah in London has now been also been given their reactivation license. These are good things. We've had 10 days ago the UKEF issuing a 50 million export guarantee for services which to do with compliance and regulatory side with Iran, which is good news, but not enough, a little bit late as far as the Iranians are concerned. They view that it's an unfortunate issue where there haven't been really any in any way the West, the Europeans, let's say, and mainly the UK, in that actually falls UK, is way behind Europe in going with the goodwill of the JCPOA. I think they are. About a year ago, I was asked the questions, what does Iran need? Actually, Justin asked me that. And when I was in Iran, I had asked around, and not many people were really very aware of the complications that the new compliances, particularly post-2008. I'm not just talking about the sanctions issues, I'm talking about the banking regulatory side. They really weren't aware of it. Iran has been away from the international banking side for well over 15 years. So these are issues, and we talked about it. When I went there, I was talking to a number of banks and people who were involved in this thing. The knowledge wasn't that extensive. You mentioned FATF. I actually came across only two people who were in the banking side who were aware of the position of the FATF with Iran. A year ahead, last November, 3 months ago when I was in Iran, these issues were very much the things that everybody was talking about in financial sectors. They are now very fully aware of what they need to do, what needs to be done. The government is also now aware. They have already taken steps. They've put a number of laws in place in May, June, and there are a number of other plans. There are a number of plans going forward, which hopefully we are hoping certain things will happen by the end of Iranian New Year, which is 21st of March, if not soon afterwards, to try and bring things together. I think one of the major issues that the Iranians feel is the fact that you've talked about convergence and divergence of the EU and US. Yes, you're quite right. We have the convergence. Then on implementation, we see there is a definite divergence. And I think unless we get back to convergence, it is going to be very difficult. I think Iranians view this also a major issue. They feel unless really US primary sanctions to a certain degree come online with the secondary sanctions, with the implementation, things are going to be very difficult. It is not clear what banks can do, what they cannot do. We appreciate, I think they do appreciate the challenges that the UK financial institutions have, particularly because of the fines and the various things that's in there, particularly because of the just general sanctions issues that they have on the primary side. But on the other hand, Iran business effectively opened. So what does the bank do? Unless there is very clear guidance from the US and the UK government, I think, on what they can do. When we talk to governments in the UK and the US, we are being told that it is a commercial decision. But we all know it really isn't a commercial decision. And the bottom line is there's got to be guidance, so of some sort of comfort that the banks can act on and move forward. Iranians say, look to the banks, to the governments. Look, Saudis, Turkey, China, Russia, they all carry significant financial crime risks. Is Iran any different? I mean, that is the question which needs to be addressed. And to what degree is it different?
And sorry, can I ask on that point, by way of, one of the big questions that our banks, you ask how is it different, and I think it's the due diligence and knowing how you deal with due diligence on the ground in Iran. Before we move on to the questions and a bit of a broader discussion, can I ask, for a bank which is, trying to ensure compliance and to maybe looking at going back into Iran, how do they manage the due diligence aspect on the ground in Iran? Give some tips, please, on that.
I think you're absolutely right. I think due diligence, I was going to have ended actually not just complaining all the time, but sometimes from your point of view as well, the challenges that the institutions here have, including myself, if I want to do business. Because ultimately, if I'm doing business with a UK company and taking them to Iran or representing them in Iran, I need to be secure that I'm doing the right thing. And yes, it is difficult. Due diligence side is rather difficult. You mentioned about various institutions who have stakeholdings in a number of companies or financial institutions. It's finding out who's doing what, who's not doing what. I think one of the major things we have to realize is the Iranian government has appreciated that and realized that. There are a number of issues which are being handled. One of the major ones that I noticed from my point of view is the taxation. Until last year, all these institutions that you mentioned did not have to publish their accounts or be liable for any taxes. The ruling has changed on that. Now these companies have to publish their shareholdings and also their accounts, which makes it slightly clearer. I'm not saying it's happened, and I'm not saying that all of the companies have done that. But it is a step forward. It's a major step forward, which clarifies certain parts of the due diligence. But again, any company going and getting involved, they have to be very careful. They have to find companies who can help them. There are companies out there who do this and can help with that.
So we have companies on the ground which will provide due diligence to a level that you think is comparable.
Yes.
Okay.
To a reasonable level.
And the transparency aspect.
Exactly.
Yeah.
I mean, ultimately, there are, of course, as I said, I'm not a lawyer, so I'm being told these issues. For instance, with regards to shareholding, I'm told that if any of these, let's say, IRGC company has a shareholding in a company that you want to work with, if their shareholding is about 20-25%, and they are not decision makers, then you can have a relationship with them. It's finding out those sort of nuances, to what degree an institution which is still under the primary sanctions is involved with the company people are working with, or institution they're working with, and to what degree the controlling factors are there.
So can I ask just on that point, because I'm sort of thinking also about just some of our questions here, and we have one around the Revolutionary Guards, and actually how do you go about really in around identifying their ownership and how much they own and how much they are the controller of that?
The companies have to register the names of directors and the shareholders, so one can find that part. The question one needs to ask is, are these the real people who are really behind the shareholdings? These, again, there are companies in Iran who will be able to help with identifying various shareholdings.
Because, of course, our issue here is there's not really a positive, although the US say they're managing a positive list system for Iran, when you have something like the Revolutionary Guard listed, and it's like, well, who is the Revolutionary Guard?
It is one of those things that I think about 20 years ago or 15 years ago it was different. Now it's a different issue completely. I mean, for instance, one hears the name of Khatam al-Anbiya banded everywhere. It's one of the prime, what is known as the Revolutionary Guard companies who are under the sanctions list. On the other hand, you look at it this way. You go to any of the Khatam al-Anbiya companies and they actually function just like a European company. They are no longer a Revolutionary Guard company. They are an independent company. Up to now, they didn't have to publish their accounts and didn't have to pay tax, so they were wealthier than most other companies. But going forward, all these companies, although they have owned by Revolutionary Guards, but in reality, they are, for all intents and purposes, private companies. And that is something I think institutions here need to sort of get their heads around, of how to handle that, and whether they would wish to get involved with a private company which might have shareholdings who have been ex-Revolutionary Guard people.
And again, I think that will take a little bit of time to develop, and for non-Iranian due diligence providers to become more nuanced and understand the Iranian system. So certainly, we've seen and have helped people in relation to on-the-ground Iranian inquiries, utilising local Iranian contacts. But that's not the same yet as some of the other due diligence services you can get in other jurisdictions as high, for example, money laundering concern, like Russia, like Turkey, Saudi Arabia, as you referenced. I think that will take some time. It's going to take some time to develop, but it will happen. And as you say, there are shareholder registries already in play that can be accessed, etc. But again, I think for those, and it's to your point, Sarah, it's about further clarity from the government side. Until you have some certainty and clarity over that, people are going to be very, very cautious about going in head first in relation to commercial transactions.
And can I ask, I mean, just sort of moving a little bit away around the practicalities of how to do beneficial ownership and how to deal with the revolutionary guards aspect, because I do know that that is going to be an ongoing conversation,
yes.
And I think, I'm already envisaging a webinar on the structure of the revolutionary guards, having some nice photos as well would be good. But can I ask around, we have a couple of questions here, and vessels and the expectations of whether banks should now continue to screen those vessels moved from the non-SDN list. I mean, it's an interesting question on, something's been on a list and then it's no longer on the list. How do you deal with that post-sanctions environment in relation to those entities?
Well, whether a bank screens the vessels anyway is a tricky decision for a bank to go through as to what the actual risk is to the bank. But if the bank has decided that its risk dictates that it needs to screen vessels, then, 174 of them are moved from the SDN list to the consolidated list, which means it's gone from an asset freeze to a block. Which doesn't really change things. So I would say those 174 you keep screening, but all those examples there and many hundreds have just gone from lists altogether.
So we have two aspects. I mean, we have ones which have gone from lists altogether, and then we have ones which have moved into the new list system, where there's a different requirement. And clearly, I think what we will see from the US regulators is that there would be an expectation that they would be expecting a bank to screen if they have a specific risk exposure to that. I mean, Zia, would you sort of agree with that expectation?
The simple way of thinking about it is that for US persons, the Iranian link hasn't changed. The primary sanctions remain in place, and they've retained those lists for a good reason. It's for US persons to understand the nexus between any of those parties on those lists and a particular transaction. So for non-US persons that are screening US dollar transactions, etc., so our clients in the EU, etc., it remains the case.
So can I mean, just to remind everybody that US persons is a very broad term. We have a couple of questions which are hidden questions. If we can just go down. I mean, one of them, sorry, I'm trying to scroll down. One of them was in relation to a company which is trying to look at financing for goods which are moving to Iran, and they're having challenges and obviously having a bank process this, and they're saying, can we legitimately trade through a third country? So if a UK bank won't make a payment to Iran because of risk exposure, can that individual trade through a third company? I mean, I can give my response to this is that if the entity, the company, is not US exposed, then of course they can trade because they're not under the sanctions. It's their relationship with the bank that if the bank processes a payment knowingly through a third country and that bank is US exposed and it's just going through a third country, it doesn't really change matters, does it?
No, it doesn't. I mean, again, you've got to understand the US nexus to a particular transaction. Just taking that question head on in terms of, is there anything to prevent it? The answer is no. There is nothing to prevent that from an EU perspective, a non-US perspective, and many companies are looking at that. So one of the things that we know, obviously, is that most of the major clearing banks have a indirect facilitation clause within most of their policies around what trade they will and will not do with sanctioned jurisdictions below or above a certain threshold. And so if indirectly you are able to facilitate that trade, then it's less than X percent of your turnover, then it may not impact your general banking relationships with your major bankers, but you'd have to check that with whichever bank you are with.
So sorry, you want to say
I have a practical point on that one. It's actually quite a good question because it brings us a number of issues. One was there's a question about the banks under the DPA agreement. How do they handle Iran business? Which is an interesting point. And of course, the 5 or 6 major clearing banks in the UK are all under, as far as I know, DPA agreements.
Two are.
Oh, I see. Just only 2 of them. Okay. Right, okay. The rest, now, one of the things which happened in the pre-implementation time, or the JCPOA, but particularly implementation time, we were seeing that banks in the UK informing the companies that they could not do any Iran business. I think that sort of attitude has not changed. The banks are saying we cannot help you with the transaction of funds, but if you're doing your own business, it's your issue. We would no longer look at closing your accounts, because we were seeing a lot of threats to the companies that if you did your own business, we will close your account, whether the money touched the UK or not. I think that attitude is slightly changing, and hopefully that will change more as things become more clear. I have also said, I heard that there have been companies already signed contracts, talk to their banks, and although the money is not coming directly from Iran, but the banks have agreed that they could do the deal with Iran. They could receive funds, providing this not directly from Iran, and they have arranged for separate bank accounts, so that it's very clear what this transaction is. Maybe that is a way forward for the time being. I don't know. I have no idea.
So I think there's the practical element about how you move, how business moves money, and I think one of the most important things for business is to understand the constraints of the banking sector at the moment, because the banking sector, by its very nature, will have different regulatory responsibilities, and particularly on the US exposure side. And I mean, one of the questions which is being posed is, will there be further clarifications coming from OFAC on the requirements for those, whether they're under a DPA or those which are US exposed? I mean, I think, it's very clear that the OFAC frequently asked questions is a living document. We're certainly compiling a number of areas where we would like to see further clarity in liaising with Foreign and Commonwealth Office and their political negotiations with the US to try and get more clarity. So I think the answer is yes, we will see more clarity. Whether it will be able to say anything more on the DPAs, because I think we must remember that for those banks, it's with the Department of Justice, it's with other organisations. And
you won't see that.
And I agree. I think we probably won't see. I think there'll be other areas we will see more clarity, and I think individually for those banks to liaise with their enforcement stakeholders, shall we say, in the US to really look at what that means long term for them. But can I just go on to our sort of final question? If a bank agrees to use the proceeds clause in general corporate facility, agreeing only to compliance with applicable sanctions, does a drawdown in USD put me at risk of a facilitation offence? Zia, would you like to answer that one? It sounds like a legal one to you.
The answer is it depends on the particular transaction in question. Generally speaking, facility agreements where you agree not to utilise funds for in particular jurisdictions or with particular sanctioned parties are fairly clear-cut, and it'd be quite straightforward to differentiate between funds that were drawn down for that facility and other funds within an organisation's treasury facilities. But I mean, obviously, it depends on what transaction the particular corporate's undertaking with the funds that it's drawn down from the other bank. So, I'd like to give you a simple binary yes or no, but it just depends. But what we have seen, and I know it's short time, but what we have seen is a clear provision by banks now for particularly the corporate facilities on what you can and can't use the funds for, and some level of audit and assurance over whether, in fact, those funds are being utilised for purposes other than agreed in the facility.
So, I mean, I was speaking at a Iranian Business Hub conference just before Christmas, and I made some comment, and that comment was tweeted all over the place, and I've been reading it since. It's been reappearing to face me ever more, and it was basically, I said, it's going to be good business for lawyers, because actually there are so many legal nuances around this where people are going to have to think through the details and really be careful how they approach it. So, I mean, my opening comments were the business landscape in Iran and European-Iranian relationships offers huge opportunities for businesses. We've seen massive deals. We've seen BA announce they're going to start to refly direct, they're flying direct into Tehran, massive, but the compliance challenges are also considerable. So it's going to be one where people are going to have to think and be sensible. Now, I know we're coming to the very end, I would like to thank my presenters. This is the first of a number of areas in the Iranian space that the BBA will be working on. For those of you who are BBA members, please do engage with our sanctions panel. Make sure you receive the papers. We do try and keep people up to date. For those of you who aren't BBA members, we will be having other public events coming on stream shortly, so watch our website. Philip, is there anything I should say in closing other than thanking our three excellent speakers?
No, that's fine. And yes, we want to make sure that we get feedback from this webinar, and Zia and Jeremy will be delivering a workshop, sanctions workshop, on the 15th of March here at the BBA. More than welcome to register, and as Justine said, have a look at the website to register your interest on that. But no, thank you very much indeed. Thank you very much for taking the time out of your diary, everyone, on this
Nearly 300 people.
Yeah, indeed. And an on-demand version of this webinar will be pushed out to you very shortly, so you'll be able to get that as well as the slide pack as well.
Thanks very much.
Thank you.
Thank you.